next matter to come before the court this morning is in Ray R.L. Both sides will have 15 minutes with which to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time, if you let me know when you get started, I can keep you apprised when you're reaching that rebuttal time. We have read the briefs and we're ready to see the brief.
Good morning, Your Honors. May it please the court, I'm Denise Ferguson. I'm here on behalf of the appellant, Mother Christine Kirk. I am replacing Derek Check, who did write the brief, and he has since moved on to other things. I would like to reserve up to 3 minutes, or at least 3 minutes, I should say, for rebuttal. Basically, what we are starting with this brief is the definition of 2 words. We're looking at what homeless means and what eviction means. This is a case in which a child was juvenile rule 6 from his uncle's home. His mother had arrived there to pick him up, and I'm sorry, it was his brother. His older brother did not want to let him go. So therefore, he called the police, and the police showed up and prevented Mother from taking the child because she said she was in the process of being evicted and did not know where she was going to go with him.
Wasn't there something also about her mannerisms at the time?
She was a little obnoxious, maybe, for lack of a better word, because when they called the paramedics, even though they may have thought she was under the influence of drugs, everything checked out perfectly fine with her. All of her vitals were normal, and there was nothing medically wrong with her. So that may have been something that concerned them, but there was nothing that was actually found at that point in time. At a family team meeting that was held, or a team decision-making meeting, Mother also had stated that she believed she was being evicted on April 22nd. The word eviction matters, though. There's a layperson view of what an eviction is, and then there's the legal process behind eviction. People say they're being evicted, and what they mean is they're behind on their rent, or they've gotten a 3-day pay or quit notice. And even after that 3-day pay or quit, that doesn't mean they have to be out of the house right then and there. The landlord still has to go through the legal process to get them out. And that involves a court proceeding. A court has to find that they are in default. A court has to issue a writ to have them removed before someone becomes homeless. The juvenile court found that Mother was homeless because testimony stated she was being evicted. There was no evidence put in to play as to where in the eviction process it was, if there had been a legal court case filed to evict her, or anything of that nature. What she also had testified to was that if she were evicted, she could stay with friends and family until she could get into another place. The court found that that meant she was homeless. Homelessness is not defined in statute. So therefore, we have to go by the plain everyday meaning. Homeless means not having a permanent home or shelter and living on the streets.
Ask you a question though. The statute, the dependency statute says the child is homeless. It doesn't say the parent's homeless, it says the child is homeless. In this case, the child is now living with an uncle, has lived with, there's evidence the child hasn't always lived with a mother. She may have always made arrangements for the child,
Yes.
but he's 3 and he's living with an uncle indefinitely at this point.
He was staying with an uncle indefinitely, and Mother had made those arrangements. And that's interesting to bring that up because this court has found time and again that if a parent makes arrangements for their child that are suitable arrangements, then there's no need for the state to step in.
What was the evidence of a suitable arrangement on that day?
Well, Mother had left the child with this relative. There was nothing wrong with the house. The police showed up only because this relative called the police because a mother was coming to get her child.
Right, so what's the evidence of when mom left the house with that child on that day? Had her nephew not intervened, of a suitable arrangement?
Well, mother still had a residence at that point in time. She was not homeless at that point in time. She still had an apartment. She may have been being evicted from it, whatever evicted means, but there was nothing, there was no court documentation or anything else presented to show that there actually was a court proceeding to evict her, or even when she was going to be evicted.
Okay, but what about the statement at the family team meeting where she stated at that time that she had no plan where she knew she was being evicted on April 22nd. She didn't know where she was gonna go, but she had various options available to her.
She had various options, and the child was never living on the streets or without a home. They didn't give mother an opportunity to exercise those options before they removed the child and filed a complaint. They moved prior to having evidence that mother actually was homeless at that point.
Is the evidence that she left the child with her sister, in her sister's care, and then her sister left the child with a nephew?
Vesta, I believe, is the sister that you're referring to. Vesta and mother were living together. And my understanding is that Vesta may have taken the child to the nephews, but mother was aware of that, and they had taken a minimal amount of clothing over there. The child did have clothing and was being taken care of with food and everything else. Did that answer your question? Okay, I just wanted to make sure that, but these parents were never actually homeless. In fact, when they got to court, there was no evidence presented that either one of them had been living in their car or did not have a place to stay. Rather, in fact, they had a place already lined up. They testified they had to be out of their residence by May 3rd, which was the same day they had a new lease starting. So while mother may have thought she was being evicted, according to testimony, they didn't have to be out of the home until May 3rd when they were moving into a new residence. So that eviction was taking a couple weeks. And legal processes do take a couple weeks. The problem is there was no evidence presented about any legal process. It was a bunch of people saying the word eviction, eviction, eviction. And eviction in the legal sense takes a lot longer than a 3-day pay or quit. An
Does
individual.
the law require, though, if the child is deemed dependent under that statutory section, require evidence of an eviction?
My reading of that statute states that the child must be homeless, and that is a current state of being. If the child's parents or mother in an unmarried relationship has a home, the child's legal residence is with that mother. This court has also stated that. So therefore, if the mother still had a residence and hadn't been evicted, then this child still had a legal residence and was not homeless. You look puzzled, Your Honor.
Because what I'm reading here says on April 21st, when mother spoke to Officer Fellow Sick of the Acton Police Department as well as Ms. Vince from Summit County Social Services, mother stated that she was homeless and she was not sure where she was going to go with Ricky.
Mother stated that she was going to be evicted, or she thought she was going to be evicted on April 22nd. At that point in time, she did not have concrete plans, but she did have places to go. They just weren't nailed down.
She had places to go, but the question is, did the child have places to go? Because the child wasn't in the same place as the mother
Well, the child was with the nephew, or the,
after he was with the whatever.
yes. So the child had a place there that apparently was deemed appropriate because the police removed the child from mother, but not from the nephew. They did not find a danger with the nephew, if that makes sense. Does that clear up some of your confusion?
To some degree.
Okay. But if the child is not homeless, then there was no need for the child to be removed from the mother. And there was no evidence presented that either one of these parents was living without a place to stay, or if they were sleeping in their car or at a homeless shelter or anything of that nature. So there's not clear and convincing evidence that this child was dependent. And I would like to reserve the rest of my time for rebuttal, if that is okay?
You can reserve 5 minutes, and you just now reached 5 minutes.
Thank you, Your Honor.
May it please the court, Evan DiMartino on behalf of the appellee, Summit County Children's Services. We are asking that this court affirm the decision of the Summit County Court of Common Pleas Juvenile Division, finding that this child was a dependent child on the time that the complaint was filed. With regard to the statute section that was determined to have been met as far as dependency goes, 215104A states that a child is dependent when the child is homeless or destitute or lacks adequate parental care through no fault of the parent, guardian, etc. In this case, the court did not specifically find that the child was homeless. The court found that the child was dependent and listed the 3 possible parts of 215104 with the word "or" in between. So the court found the child was homeless or destitute or lacked adequate parental care. So this whole debate about the definition of homeless is really irrelevant because the court still based the decision on finding the child was destitute and also possibly that the child lacked parental care, which Judge Teodosio discussed in her decision, overruling the objection to the magistrate's decision, noting that at the very least, mother is trying to say, well, I dropped my child off at my nephew's house for a couple of days with one change of clothes. No plan was set in stone, the nephew stated. Then mother, who doesn't have a working phone, she wants to come back and pick up the child on the 21st. She shows up yelling, hysterical, pounding on doors, pounding on windows. She had walked 3 miles barefoot to pick up the child. Child had no coat. She wanted to just take the child and walk him back, I suppose, the 3 miles. Again, she's barefoot with no real plan of where she's going to go. Her statement was to the caseworker on the 22nd that she was being evicted and she had no place to go. She did state that she had some friends she could stay with, but she had nothing in place. So she wants to say, well, I dropped my child off with my nephew and therefore that's adequate. I had parental care there was a plan in place, but there wasn't. And that's shown by the fact that she showed up to get the child. So if she had a plan in place and that plan was, I'm gonna leave my child with my nephew, then the evidence in her own statements contradicts that plan because she went to get the child back. And her behavior, regardless of whether she was not on drugs that day, her behavior was inappropriate, it was unstable. In the SAR that's in the file that's dated, I believe, May 31st, there's notations that mother said that she was unstable and incapable of taking care of her child, and that's almost a month after this complaint was filed and the child was taken into shelter care, into temporary custody, and then adjudicated to be a dependent child. There's absolutely nothing in the statute and nothing in the understanding of what juvenile law is, I want to say, to support this idea that in order for a child to be dependent under 215104A, that child has to have been residing in a house that has been fully evicted and the parents are now completely out of the house. The idea of dependency is to help a child when they're in a situation that they need the state to come in and help that child out, whether they're homeless, they're destitute, or they're lacking adequate parental care under 215104A. There's absolutely no support for this argument that there has to be evidence in the record of an actual eviction that was filed and when the date is that they're going to be evicted and homeless. Mother believed she was going to be homeless. Her boyfriend testified that he believed that they were going to be evicted and out of the house. He thought the date would be May 3rd. which would be about a week later. But nonetheless, he also believed they were gonna be evicted. So there's no evidence to contradict the judge's finding that this child was homeless, destitute, or lacking adequate parental care. And there's no evidence to support this argument that maybe mother was using this colloquial term of eviction. She was being evicted, there's no doubt about that. She knew it and she meant it. She might not have realized that she had a couple more days in that house, but irregardless, she was being evicted. She had no plan for the child. She never discussed any plans for what she was gonna do with her child once the eviction happened. She just said she could stay with friends. And again, left this child with a nephew with no plans in place and basically one change of clothes.
How do you address Attorney Ferguson's contention that the mother did provide adequate parental care by making sure that the child was with a relative who was able to take care of the child?
Right, that was for a few days. And there was nothing set in stone as to what the plan was going to be long-term. So even if the child, let's say, for the few days that the mother dropped the child off with the nephew, even if those few days were adequate parental care, when she showed up on the 21st, which was the date that the child was taken into custody with the juvenile rule 6, on that day, she came back and she demanded the child back and was acting very unstable. So on that day, which was the date of the filing, which is the date at issue, the child did not have adequate parental care because she was coming to take him back. She had revoked any plan that she had with her nephew, and that plan was clearly not long-term. If you bring a child over with one set of clothing, that's no indication that you're gonna leave that child there for weeks or a month on end.
Counsel, I'm still a little confused as well over, I know that the trial court did say, repeated the words of the statute, was homeless, destitute, adequate parental care. But this was on a motion with objections for the finding of the magistrate that the mom was homeless.
That was part of it, right? They were disputing the funding under A and were arguing about the definition of homeless.
Right. So I guess I'm having a hard time trying to figure out how the court, even though the court says those words, really the whole nature of everything was the homelessness factor.
Part of it was on the objection, yes, but the finding for dependency was based on A, and in the court's decision, the court specifically says, I find that the children are dependent, and then lists the 3. So even
But what
going
I'm
back,
saying is
right,
there's no analysis though
of the other
It's
two
just-
factors,
Yeah,
right?
it's like it's just a parodying of that, but really the whole thing is about homelessness. That's what I'm trying to.
The objection, right, the objection was based on that, and then the court goes into what the factors were to show that in this case, this child was homeless. So there's nothing in the statute that requires that there be any filing of any eviction or eviction notice, any of those things that the appellant is trying to argue that this court should set as a bright line rule for a finding that there's homelessness for a child. The purpose of the juvenile court laws and the juvenile court statutes are completely different than the rules for eviction, et cetera.
And I understand that, but I guess what I'm still struggling with is, when do you call this premature? In other words, a parent says to a police officer or something, next week, I'm gonna have to move out of my house. I don't have any place to go.
Right, except
Next month, I'm gonna move out of my house and I
Right.
don't have any place to go. Take eviction out of the equation.
Sure. Well, she said, I won't have a place to go tomorrow. She said on April 22nd, I will have no place to go, and she said that on April 21st. So that would be the difference. I mean, in this case, what she testifies to later, the information at the time of the complaint, which was what the complaint was based on, and then the same evidence was introduced at the adjudication was, this woman had dropped her child off, she shows up on the 21st and says, I have nowhere to live tomorrow, I'm being evicted, whatever word you want to use, I have nowhere to go tomorrow, I want my child back, banging on the door, banging on the windows. So at that point, what are we supposed to do? Hope that she's wrong and she has somewhere to go tomorrow?
Let me ask you this. You filed the complaint immediately, and the next day, she has a place to live. This child is still dependent, even though there was no time period when they were without a home?
At the time of the filing of the complaint, that child would have still been dependent. And we would still have to verify that mom had somewhere to go and somewhere with the child.
At the time of the disposition of an objection,
Mhm.
filed the magistrate's decision,
Right.
adjudication, now we get down to the disposition hearing.
Mhm.
Did mom have an obligation to raise again her objection to the adjudication at that time because she waived the right to trial at the disposition and agreed to put the child in temporary custody to the aunt and uncle, or I think it was aunt and uncle, wasn't it? Yeah.
Yeah.
I mean, did she have a duty to reassert her objection to the magistrate's decision of adjudication at that time?
I don't think that, in good faith, I haven't researched that, and in good faith, I couldn't say that I think that she would have had to raise it only because the court was aware that there was an objection pending on the adjudication, and that was noted at the time of the disposition. So I don't, as much as that would make my argument much easier, I suppose, if it was waived, I don't know that that would be, I haven't researched that specific issue, and I don't know that that would be maybe unfairly burdensome when everyone knew. There's no argument that there was a lack of knowledge that this objection was pending. Disposition just had to be done, and it was done in a timely manner so that the disposition was still pending. So regardless, I understand that the issue with, if it's one day and when is it premature. However, with Summit County Children's Services, when we have issues like this, it's hard to not act right away, even when looking back, maybe it might seem premature. But this mother had a history of mental health issues, had a history with the agency. She had 4 other children that were removed. So there was more to it than just someone left their kid with a relative and then showed up and said, I don't know where I'm going to go, but I want the child back. She showed up acting unstable. She showed up without a plan. She showed up believing she had nowhere to go. And for how long that was, we didn't know. Even if it was not until May 3rd, let's say she was out on the 22nd, the 21st, and then nowhere to go the 3rd, that's still a significant time to have no plan for a small child on where you're going to go and how you're going to care for that child. And if there are no further questions, I would rest on brief.
Thank you.
Thank you.
Your Honors, I'd just like to address a few points. One thing about Mother came over and was acting unstable, allegedly. Mother came to get her child, a child that she was the sole custodian of, that she had every right to have with her for even an hour, or to take to lunch, or to take with her when she moved. Mr. Kirk had no legal right to keep this child from her. And that's what he did. He interfered with her custodial rights, which in many instances could have resulted in him being charged with a crime. Because parents have the authority to have their children with them, and no one's allowed to interfere with that. And that's what Mr. Kirk was doing. So if you look at it from that perspective, what you see is a mother who's being told, no, I'm not letting you come in, I'm not giving you your child back. So yes, she was pounding on the doors, she was pounding on the windows. It makes sense if you're thinking that it's her child, and she's being denied for no good reason her child. The other thing is, the other thing I'd like to address is that while the complaint alleged that mother was going to be homeless on April 22nd, the day of the filing of the complaint, they never proved that she was homeless on the date of the complaint. They did not provide that information and prove by clear and convincing evidence that mother was homeless. And I believe that is a very big issue and a big fact that needs to be considered. If they're alleging mother's going to be homeless on April 22nd, and that's what they put in the complaint, and that's why they removed the child, then they should have had to prove that mother was homeless, was without a place to stay, and was without a way of caring for this child. The agency did not do that. The state did not do that. Even the judge stated that while mother stated she was being evicted that same day and did not know where she would be staying, and had no plan in place for the care of the child, there's nothing stating that mother was definitely homeless that day. There's no finding that mother was homeless, or that the child would have been homeless if the child had been in mother's care. And if the child, per statute, is supposed to be, under that statute, is supposed to be, is homeless, is a present tense. It doesn't say will be homeless, or will be destitute, or without adequate parental care. A couple other things that were brought up was that on May 31st, mother did something. May 31st is out of this equation, because that is beyond the date of the complaint, which is April 22nd. So what happened 6 weeks later matters not when we're talking about adjudication. I would ask that this court reverse and remand this adjudication and find that the child was not homeless and the court did not meet its burden, or the state did not meet its burden. And with that, I thank you.
Thank you both for your presentation today. The court will take the matter